Now, that, I think, raises in a very clear way the constitutional issue that underlies this whole legislation, because it is part of the Constitution that it is for the appeal court to determine sentencing, except to the extent that legislation lays down what the sentence should be. To read this, you would think that this was a bill just to appoint some other quango, but in fact, there's a huge constitutional question underlying this, and that's what troubles me.
Nigel Dodd.
Thank you very much. I'm grateful to Lord Gill for reaching that point, because that's the point where I'd actually like to come in, because your submission to us at paragraph 8 states, and I start halfway through a sentence, the High Court has always been and remains the body ultimately responsible for decision-making in the development and implementation of sentencing policy. Given that prison, a fine, admonition and discharge, and indeed execution and probably transportation, certainly predate any Parliament, I'm sure that's true as far as those kind of penalties go. But would it not be fair to say that anything to do with probation or community orders or drug testing and any of that kind of stuff is a creature of Parliament? And would it not be fair to say, therefore, that the development of sentencing policy has in fact been parliamentary rather than judiciary over at least recent history?
Well, no doubt, certainly statute, and that is to say acts of Parliament, have brought into range a number of sentencing options as to what in the modern community are thought the appropriate disposals in relation to particular facilities for the sentencer. But I think the question as to whether the sentencer has the option of prison or a community service order or the like is a different matter from what his actual decision-making is, or what is the range of his decision-making in that particular matter. And it's the question of the range which has been the matter that's been truly germane to the exercise of authority by the courts hitherto.
But I think my point is about the constitutional issue here, because I think that is the nub of it, and I understand entirely the sentiments that you've put down here. Parliament has decided that capital punishment is no longer appropriate and has removed the boundaries. Surely it is open, I'm not suggesting anybody should do it, for Parliament to say we will no longer put anybody in prison. Absolute nonsense. But we could do it. Okay? And surely that is a matter of policy. And if we were to do that, then that would be sentencing development, or undevelopment perhaps. But surely it is for us to do that rather than yourselves. And if we were to do that, you would be stuck with it. Now, I apologise for an extreme example, which you will obviously see straight past. But I'm trying to distinguish between policy development, which I think is actually for us, for better or worse, and individual sentencing, which is very clearly and unambiguously for yourselves.
Well, there may be a question as to the propriety, as to in which arm of government particular functions properly lie. But we're not being asked in this particular bill to contemplate the Parliament actually itself dealing with the matter of guidelines. It's not that Parliament is going to actually make the guidelines. Parliament is, going to strip the High Court of Justiciary of powers it otherwise had, and is going to pass on to a non-elected, non-judicial body the function which the High Court has exercised hitherto. And that's where I think I find the particular difficulty.
So, if I get you right, then, if we were to retain, say, within this committee for practical purposes, the development of policy and the processes which the Sentencing Council is about, you would be happy, because it would then be Parliament developing policy.
Well, the question is whether you could do that practically in any meaningful way. I think I still would have an issue of the propriety of that particular course, because there is a debate as to whether or not, even though it is technically within the powers of the Parliament to say there shall no longer be imprisonment, there is a question as to whether it would be proper for it to do so, and likewise there's a question as to whether it would be proper for it to remove from the High Court the powers it's exercised hitherto.
Thank you.
Thank you, Convener. I wanted to pick on the fact that the panel had said that there was no empirical evidence for inconsistency in sentencing, and I wondered if the panel was aware, well, I'm quite sure you are aware, of the report in 2006 completed by the Sentencing Commission, which I believe was chaired by a High Court judge, and the membership included other judges and sheriffs, which said that such evidence does exist, although limited, and supports the view that there is some inconsistency in sentencing in Scotland.
If I can just come back on that, Ms. Constance. I think it made clear that so far as there was any evidence, it was anecdotal evidence, as it were, rather than any study which had actually been made into that particular matter. It took the view that it would be take too long, given the constraints of time which it, as a commission, had to deal with the matters, for an exercise to be carried out. I'm not sure that I accept that it would take long. It does appear to be that if the right materials are made available, the exercise could be quite short. But I think it did recognise that there was no study which gave support to the proposition that there was, in fact, an inconsistency in sentencing.
It did say there was some evidence to that, and is it not the case that one of the proposals included within the Sentencing Council is actually to undertake some of that more in-depth research?
Well, the in-depth research is not, well, I suppose to some extent would be into whether or not there was inconsistency of sentencing, but in a sense that puts the cart before the horse, because you really want to know that there is truly an inconsistency of sentencing before you go into this very expensive exercise of setting up a body with the funds which have been indicated, more than £1 million a year, in relation to the operation of a body of the particular kind envisaged in the bill.
Yeah, I would accept that if that was the only case for establishing a sentencing council, but I'm sure as other questions we'll explore later, it's actually about society having an input in the core values of our criminal justice sentencing.
I just say that I have no problem in relation to society having an input. I mean, if it is thought financially justifiable to have a body of this particular kind, then I can see advantage in there being persons from society in general involved in the Guideline Council. But what I would suggest is that that should be on an advisory and an informing basis rather than on a determining basis, which should be left to the High Court itself.
We must move on, having dealt with that particular section, and turn to the purposes and principles of sentencing with Cathy Craigie, please.
Okay, thank you, Convener. Good morning. Lord Hamilton, in your submission, you say that we are content with the purposes and principles of sentencing should be set out in statute. What do you think it's helpful? Is this, as a layperson, it seems to me that the purposes and principles been set out there is something that we widely know. We would expect people sitting in judgment, folk to widely know what the principles and the purposes. Where do you think that this is necessary?
Well, I don't think it's essential. I mean, and I'm not sure to what extent people who otherwise are ill-informed are going to actually read the terms of an Act of Parliament to discover what are the purposes and principles of sentencing. I think it's been done in a variety of jurisdictions, and I think this draws from the English experience, although there are one or two aspects of the matter which are perhaps new. And it also reflects, to a large extent at least, what the courts in fact do. But I have no particular difficulty if it is thought that it will assist in members of the public understanding what courts are doing and what sort of principles they are looking to in order to decide on particular disposals, of them having access to that by it being set out in an Act of Parliament. I don't regard it as a critical matter, though.
Okay. If you say there it's been done in other jurisdictions, is it just England, or has any research been carried out